Well, welcome again to everybody that's joined us for this session of the 2013 AgrAbility Virtual National Training Workshop. Our session this morning is on product liability law in the farm equipment industry. And our presenter today is George Vernon, who is an attorney from Monroe, Wisconsin. And George is also a member of our National AgrAbility Project Advisory team. And so we're very appreciative of his roles in both that organization and also his willingness to share with us his expertise this morning. Before we start, I did notice some people that I did not recognize in the attendee list, so perhaps this is your first webinar that you've participated in through AgrAbility, and so a few instructions. You do, of course, need headphones or speakers to hear the presentation, as there is no phone connection. You may check your connection speed through the meeting menu at the top left, and then go to Manage My Settings. Dial-up is not recommended. If you have any questions about the content of what's being shared during the presentation, please feel free to type those in the chat window on the left side of your screen under the video feed. Also, at the end of our presentation, during the question and answer period, if you have a web microphone and you would like to ask your question verbally, please use the raise hand icon at the top of your screen. You can just click on that. It will indicate that you have a question, and we will attempt to activate your microphone. We'll be doing our poll questions at the end, which only takes a couple minutes, so we appreciate your input on that. We are recording this session, and we will be archiving it on the AgrAbility website under the Online Training and Virtual National Training Workshop menu. If you have any technical issues, for example, if you're not able to hear or see, please use the chat window. If you're not able to use the chat window, then please send us an email via agrability@agrability.org, and we will monitor that account during the presentation. If you're experiencing any echo, you might try seeing if you are logged in more than once. You can always log out and try again. If we are disconnected with our presenter, please just hang on and we will reconnect as quickly as possible. And if you are disconnected, please just log in again. If you are new to AgrAbility, we are a program sponsored by the U.S. Department of Agriculture that focuses on issues of disability in agriculture. There are currently 20 projects around the country covering 22 states, and each of those projects is a partnership between the state's land-grant university and at least one disability services organization. In addition to the state projects, there is one national AgrAbility project, and that's led by Purdue University's Breaking New Ground Resource Center, with the partners listed below: Goodwill of the Finger Lakes, the Arthritis Foundation, Heartland Region, and our evaluation team through the University of Illinois at Urbana-Champaign and Colorado State University. If you would like any more information about AgrAbility, visit our website, www.agrability.org. We also have a variety of archived webinars that have already taken place on that site if you are interested in this material and would like to explore further webinars that we've held in the past. At this point, I'm going to turn things over to George Vernon, and I will disconnect my camera and microphone, and he can enable his camera and microphone, and I will plan to return at the end of the presentation for our
Okay, did I do it? I'm George Vernon, and I'll be speaking to you this morning about product liability law. I have on this first slide a summary of where we're going. We're going to start with a brief history of product liability law, essentially for the last 100 years. And then we're going to take a look at a couple of case studies. There are some changes to the facts, but these are based on two actual cases that I've worked with over the course of my career. The first one I'm calling Gonzalez. It is offered because we're going to talk primarily in that case about liability and how what some typical claims are in a product's case that relate to product design. We're going to see how legal doctrines that are typical in many states affect how liability and fault gets allocated among the parties in a case like that. And we're going to talk somewhat briefly in that case about the elements of damages. Our second case study will be a case I'm calling Smith. And this is a catastrophic injury case, a quadriplegic case of a young man. And we're going to focus in that case primarily on damages to show you what kinds of damages are available to be awarded and how damages in a lawsuit interplay with other benefits. The most important of those are insurance that may be available and public benefits, particularly Medicare and Medicaid. So we'll start with our history. I call this what liability law looked like 100 years ago as liability in the dark ages. Liability could be imposed on you on the basis of tort or on the basis of contract. Tort is a form of recovery in negligence, essentially for people that do not have a pre-existing relationship of any kind. I run over you with my horse and buggy, I injure you, you can sue me in tort claiming that I was negligent in driving my horse. There was another strand of law developing that was contract-based, and it was, for example, I sell you a new car, the brakes fail, and you smash into a guardrail and hurt yourself. You have a contractual relationship with me, and that may govern your rights to recover against me. Or I sell you a gallon of milk, you invite your Aunt Tilly over for lunch, and she drinks the milk and gets very ill. Your Aunt Tilly may or may not have a contract claim against me. In the Dark Ages, there were weird doctrines that protected defendants and essentially made it harder for plaintiffs to recover damages. And this was sort of just in keeping with the self-reliant age in which everybody was supposed to take care of themselves. The plaintiff's claim would fail if there was contributory negligence of any kind. If you stepped off the curb without looking and I was driving my buggy down the road way too fast for conditions, nevertheless, you had some contributory negligence and that would bar your claim entirely. If you assumed the risk of whatever injury you covered, for example, if you were working with a dangerous machine and everybody knew it was dangerous, there's a doctrine of assumption of risk. You assume the risk of using that product. That would typically, in those days, have barred your recovery. In the contract strand, there was a doctrine of privity of contract. If I sold milk to you and you got injured by it, that was okay. You had a claim. But if your Aunt Tilly got injured by it, well, she had no contractual relationship with me, and she couldn't recover. Each of these doctrines essentially prevented a plaintiff's case from going to the jury. The law evolved over the 30s, 40s, and 50s, and in the early 1960s, what I call the product liability revolution began. And the main thing that happened in that revolution was that some of these weird doctrines that limited liability, they were deemed to be too restrictive, and the judges, the lawyers, the system in general felt they needed to be changed. And there was also a very substantial input to this revolution from the dark science of economics. Economic analysis of the law and of legal doctrines started to be very fashionable in the 60s. And as applied to products liability, the main teaching was that in an industrialized society, injuries are inevitable and there should be a way to spread the costs of those injuries across society as a whole rather than have them be borne by the injured individual. Now, typically and historically, that was done in some degree by insurance, by workers' compensation law, and so forth. But it was seen that it should also apply to the private legal system. And the most efficient way to spread those costs was to impose them on the manufacturer. And that doctrine was essentially adopted in the early 1960s through a document called the Restatement of Torts, which one by one got adopted by nearly every Supreme Court of every state in the Union. This product liability law is almost exclusively a matter of state law, so it does change or differ somewhat from state to state. So the doctrine of strict liability was born, and it was, at least in the law review articles, said to be liability without fault. A manufacturer is strictly liable, whether at fault or not, if he or she creates an unreasonably dangerous product. And the definitions of unreasonably dangerous product varied from state to state, but the two essential, most common ones were a product whose risks exceeded its benefits, or a product that was dangerous beyond the contemplation of an ordinary user who was experienced in its use. So an important question is liability without fault gibberish? And I think it really is. It's lawyer speak, but when you actually started looking at the cases, there's no meaningful difference between a manufacturer's failure to exercise reasonable care, which was what we would say to impose negligence liability, and a manufacturer's failure to design a reasonably safe product, which is the strict liability standard. In both cases, the manufacturer's conduct is going to be weighed, and did the manufacturer do as much as he should have to make the product safe? So to say that we focus on the product, not the conduct of the manufacturer, which I guarantee you there are 5 million cases out there saying that, is really kind of just words that don't have much meaning. Because in any strict liability case, the manufacturer's conduct is front and center. The manufacturer is going to have to prove that they did all in their power to make the product safe and would have prevented the accident that we're here in court talking about. Part and parcel with strict liability, these weird defenses melted away. They disappeared because the restatement weakened them, or state supreme courts or legislatures eliminated them. So the initial results of the revolution, by the early 1970s, mid-1970s, the situation was that almost every case was for the jury to decide. Almost anyone could be a design expert. You had to have some credential, but there wasn't much limit on an expert going into court and testifying that a product was defective. And when he did so, the merit of the design is always judged in the context of a grievously injured plaintiff. John Deere can manufacture and sell 50 million combines or tractors, but the only time their safety ever gets judged in the crucible is when there's a paralyzed or a very grievously injured plaintiff in court, probing every aspect of that design and every safety feature that could have been added that wasn't added, whether it's would be deemed by farmers to be a reasonable safety feature, too much of a hassle, gets in the way of performance, and so forth. So it's a fair question whether that's a fair forum in which to judge the safety of a product. But in our system, it is the forum that is used, and in most cases in the farm equipment industry, there is not another forum. Now, the counter-revolution, I say, began in the mid-90s and continues to the present. And essentially there has been a swing back towards giving more protection to defendants and making it harder for plaintiffs to present their cases. This happened because there was really concerted effort in many states on the part of the business community to get more conservative state Supreme Court and trial court judges appointed. Generally those judges are appointed in states, and many states are elected, but whether they're appointed or elected, the impact of the business community or anyone else who's interested and wants to publicize, advocate in favor of a candidate, give money to their campaigns and so forth. Anyway, the judiciary is much more conservative as a whole than it was 25, 30 years ago. Public opinion played a part. The McDonald's coffee case got a lot of attention, and it sort of gave sympathy to the idea that, hey, these trial lawyers are going crazy and people can do anything stupid and still get a $1 million recovery in court. The U.S. Supreme Court weighed in with some very important pivotal decisions. One of the most important ones is they essentially has put a constitutional cap on punitive damages, and that's a federal constitutional interpretation which applies in all states. The case was BMW versus Gore, in case you may have heard of, where someone bought a BMW that they thought it was presented to them as being new, but in fact it had been previously sold once and it had a small accident, some scratches, and front fender had been repainted, and the consumer was awarded, my numbers may not be right, but something like $4,000 in compensatory damages and $40 million in punitive damages. Which that kind of thing can happen in many jurisdictions in this country. Well, the Supreme Court said there has to be some reasonable relationship between the punitives and the compensatory damages, and there's kind of a rule of thumb now that they can't be more than like a 4-to-1 ratio. Another important thing the U.S. Supreme Court did was adopt a threshold standard for allowing expert testimony to even be admitted in court. That's the so-called Daubert test that grew out of a drug case against Merrill Dow Pharmaceuticals. And essentially it says that an expert who's going to testify in court is held to the same standards as he or she would be held to if they were writing a peer-reviewed article for their discipline. You can't just draw a design on the back of an envelope and say, here's something I think would work, and get your case to the jury. Now that Daubert decision was a federal court decision, and it instantly applied in all of the federal courts, but in the state courts it had to be adopted by the states, and one by one most states have now adopted the Daubert standard. For example, in my home state, Wisconsin, they just got around to doing that last year, even though the doctrine's been around for 10 years or so. There was also pro-business tort reform in the states. I'm sure familiar with that from the press. One thing that's been done is statutes of repose. Say if a product was first sold at retail more than 15 years ago, you can't bring an action based on the alleged defect in that product. The idea being that if it operated safely for 15 years, it's sort of presumptively reasonably safe. Caps on non-economic damages have been commonly introduced in many states. This has primarily been in the medical malpractice field, but in some cases it's applied to other types of damages as well. Non-economic damages are things like pain and suffering, things that aren't pocketbook damages, such as lost wages and so forth. And we'll talk more about that distinction later on in the presentation. Bottom line for pharma equipment manufacturers, can a company be confident that it's designed a reasonably safe product? They can't be, because the standards that they, if I jump down to the third bullet point here, many industries, like drugs, for example, before a drug gets introduced to the market, the FDA requires testing to be done on it. The companies have to show that it's safe for the uses that they're offering it to the public for. And once the FDA certifies that drug, there's somewhat of a safe haven for the drug manufacturer, as long as they're not expanding maladies that it's being used for, as long as their testing was validly conducted. The FDA's blessing of the drug is said to preempt the field, so a jury can't come in and say, well, we don't really agree that penicillin is not safe in treating malaria. The FDA has made that judgment, and it's deemed to be an expert judgment that juries shouldn't be second guessing. But in the farm industry, the only thing there is industry standards, which are drafted by societies like the Society of Agricultural Engineers, and they are some evidence that your product is reasonably safe, but they are not conclusive. And the jury and the plaintiff's experts have the ability to say, no, well, that standard isn't strict enough, and standards should have been stricter. So if the manufacturer complies with standards, complies with state-of-the-art, they nevertheless can still have a jury come in and say, that's not good enough. And again, back to the middle bullet point, that judgment is always being made in the context of a grievously injured plaintiff sitting there in court in front of the jury. So now we'll move on to our two case studies, and the first one is the Gonzalez case, in which we're going to focus on liability and allocation of fault and liability. Mr. Gonzalez is the plaintiff. He was a 48-year-old farm worker, and he was injured by a tractor-powered rotary mower while mulching tree prunings in an orchard. This accident happened in 2001. Mr. Gonzalez had been born and raised in Mexico. He had been in the U.S. for about 11 years, working as a farm worker for all of that time at the time of the accident. He earned $5, a little bit more than $5 an hour. He had 4 children, 3 of whom lived in the U.S. His wife had stayed in Mexico, but had only moved to the U.S. after he'd been here for 10 years and had lived in the U.S. for about 14 months before the accident. The accident involved a Massey Ferguson tractor, which was a vintage 1989. Now that date is important because the standards that are applicable in judging the design of a tractor or any other farm machine is the date at which it was designed, manufactured, and sold. Everybody understands that modern tractors have cabs, they have roll bars and seat belts. You know, a 1935 John Deere has narrow front, no seat belt, open cab. People roll those over all the time. They're far less stable than normal tractors. Rollover injury is by far the most frequent and disastrous source of farm injuries. The statistics on that are overwhelming. Just in terms of numbers, all other farm injuries pale by comparison with that. So a lot has been done to make tractors safer for the rollover risk. But that 1939 tractor, it's very difficult to get a verdict on the basis that it was unstable and didn't have a roll bar. Although, as I say, it's not as a matter of law. There's no safe haven. But the older the tractor, the less likely a jury is to be persuaded by that argument. Now, just a little bit of technical stuff that may be familiar to many of you, certainly any of you who've worked on a farm, but the way this machine works, it's got a power takeoff in back, and there are a lot of implements that hook up to the power takeoff on a tractor, and the tractor's power operates the implement. The PTO is an abbreviation for power takeoff, and the shafts that attach to the PTO are another frequent source of injury because those shafts rotate at a high speed, typically 540 RPM, and if you're around them and you stick your hand into them, bad things can happen. The purpose of the PTO, as I've said, is to provide power to implements, and if the tractor engine is on, there's a separate lever that engages the PTO, and that once that is engaged, the PTO starts spinning. And if there's a shaft attached to the PTO, that shaft will start spinning. But conversely, the operator can move the PTO lever to neutral, in which case the PTO will stop spinning, and there may be some coast down period, but it will stop spinning. But the tractor engine can continue to run, and the tractor can be in neutral and standing still with the PTO engaged or with the PTO disengaged. So in many cases, tractors are used kind of as a stationary vehicle. They back the tractor up to a grain auger, for example, attach the grain auger. The tractor just stands there, and the grain auger is powered by the PTO of the tractor. Now, this case involved a Bush Hog brand rotary mower that had it's a big, heavy-duty mower used in ag, capable of cutting down trees up to 3 inches in diameter. The mower vintage was 1978. And now you can see barely in that slide, there is a shaft that connects the mower to the rear of the tractor. This is what that shaft looked like when it was new. The shaft was fully shielded, which is typical, and that's the way farmers are protected from that rotating shaft and from entanglement in that shaft. The front shaft was a yellow plastic. You can see it. This is after the accident. The shafts have all been replaced, so this is a pretty new shaft. You can see it provides pretty good coverage. And then if you look immediately behind the yellow shaft, you can see a red hood-type shield, a steel shield, and that protects the back section of the shaft. It's a two-piece shaft, as I said. Now, at the time of the accident, this is what the shaft looked like, and all that yellow shielding on the front was gone. You can see that big so-called universal joint where the front shaft connects to the rear. That's obviously a big knuckle there, a prime area to get your clothing or anything else entangled in. Here's what the rear shaft looked like. Again, that hood shield was long gone. Now, this accident occurred in the month of February. The peach trees had been pruned. There were prunings lying on the ground. How do you get rid of those? You can rake them up and haul them away, but it's much more efficient to just mulch them in place, and that's what was being done. You can see this mower has an offset attachment so that you can get a more efficient pruning by having part of the mower be hanging out, side straddling the side beyond the wheel width of the tractor. That's how it was being done. Now, some of these prunings got caught up in the front, the intake of the mower, and the safe thing to do would have been to shut the PTO off, get down, pull those out, and then go back, get on the tractor, and start the PTO again and go on your way. But Mr. Gonzalez, as often happens in the farm business, didn't do that. He left the tractor engine and the PTO running. He got off to pull the branches off, and he slipped, and his clothing got into that rotating shaft. These are police photos taken after the accident. This all happens in a split second. He gets caught in the shaft, he flips around, he gets thrown clear of the shaft, but his clothes are entangled, and that's what it looks like after the accident. As a result of this, he lost an arm. He had other internal injuries and other related injuries we'll talk about more. So there's your case. Now, how does the plaintiff prove that case? Against Massey Ferguson, there were basically a couple of claims. First, that they failed to install a safety switch on the tractor seat that would have shut off the tractor engine when the operator leaves the seat with the PTO on. Shutting off the engine, you could theoretically design this switch so it would shut off the tractor engine or it would shut off the power takeoff. Either one would have been sufficient. As many of you know, if you've got a riding lawnmower, consumer and lawn and garden tractors have had this kind of a device for years, a kill switch in the seat. If you lift your weight off the seat of the garden tractor, the power shuts off. And this could easily and technologically feasibly be done on farm tractors, and really nobody debates that. However, Massey Ferguson says, look, a farm machine is much different from a consumer mower. Our designs are governed by agricultural industry standards developed by the ag engineers, and those standards don't require that kind of a switch. They didn't in 1989, and they still don't today, because it's a completely different animal. Farmers are on their tractors 8 or 12 hours a day. Sometimes they need to stand up. Sometimes they just to rest their back. Sometimes the tractors are being used in a stationary capacity, for example, powering a grain auger, as we said earlier. Are you going to make them put a brick or something in the seat of the tractor so that power takeoff keeps running? It's just not feasible for the farm industry. So those were the arguments there. With respect to bush hog, the claims dealt with warnings and with guarding. Now, warnings are sort of the catch-all. Everybody knows that at a minimum you can warn about something. Well, in 1979, the state of the art for warnings was a lot different than it is today, where most machines these days have 15 different decals on them, each decal having 10 different warnings and a lot of diagrams of people getting chopped up. In the old days, the warning decals were a little more sparse. But the warnings claim was that there wasn't any warning that told the guy that the shield was missing, and there wasn't any warning that told the guy that, hey, if you stick your hand in this rotating shaft, something bad could happen to you. Now here's this 1978 vintage warning that was on the machine. It's pretty feeble by today's standards. Caution, keep a safe distance from the mower. Well, what's that mean? Stop the power takeoff before dismounting. That's pretty clear, and that's pretty good advice. Keep your hands and feet away. That's pretty good advice. Keep your safety shields in place. In 1985, 7 years after the thing hit the market, the driveline manufacturers came together and came up with a pictorial decal that was thereafter put on all drivelines. And this is what it looks like. It's a little more dramatic in terms of the impact of the visual. But the basic text message is the same. Hey, this thing can hurt you. Stay the heck away from it. So bush hog's defense to that warnings claim is that everybody knew the driveline was dangerous. The danger was obvious. Now, there's a legal doctrine that says if a danger is obvious or known to the injured person, there is no duty to warn. And when I say duty, that's important, because whether or not there's a duty is a question for the court to decide, not for the jury to decide. These days, it's very unusual for a case to get decided on the basis of no duty, because the duty to warn has expanded geometrically since the late 70s, and that's why machines are covered with decals rather than the manufacturer taking the position that, well, I don't have a duty to warn, I'm not even going to use any decals because everybody knows that that drive shaft is dangerous. Bush hog also made the argument that it's Farmer Jones's job to maintain the shielding, and a decal, there was a complaint that the decal should have been in Spanish, so that it could have been understood by Mr. Gonzalez, but it wasn't his job to change the shields anyway. Bush hog also had claims against Farmer Johnson. Everybody knows that those shields need to be there. You don't need a decal to know that. And in fact, we were able to go around Mr. Johnson's farm, and he had 10 or 12 different implements. Every single one of them had a driveline shield on it except this one. So his claim to, well, gee, I didn't really know there was supposed to be a shield there, that really didn't cut much weight in credibility. He'd been a farmer all his life. He'd been on a tractor since he was 4 years old. So we could say with some credibility, I represented bush hog, by the way. Anybody in a farmer with his experience certainly knows that shield should have been there, and a decal is irrelevant, and more decals wouldn't have made any difference. So then you get to the guarding claims, in which the plaintiff essentially says everybody knows that these shields wear out, they get removed, they get bent, and they're kind of get in the way when you're trying to change a bolt or attach or disattach the machine. So they get taken off because they're inconvenient and they get in the way, and thousands of farmers get injured every year because of that. So these shields need to be designed better. And the plaintiff says, look, it's bush hog's duty to make a better shield, and they've done nothing to try to improve it. It's feasible, they would say, to make an interlock shield, so that if the shield gets removed, somehow the machine doesn't work. You might be able to figure out some electronic interconnection between the shield and the PTO switch, so that if the shield was removed, the PTO wouldn't work. We never did see what seemed to be even a remotely feasible design proposal for an interlock PTO shield in this case. And besides, bush hog says we buy those shields from others. We don't make them ourselves. So all we can do is buy the best that the drive shaft manufacturers offer. So Mr. Gonzalez obviously has some fault here too. You know, shouldn't he have known not to get close to that thing? And not only that, Farmer Johnson said, well, I trained him, even if he didn't know. I told him repeatedly he shouldn't be getting off the tractor without shutting the PTO off. And Mr. Gonzalez says, yeah, it's true. I knew it could hurt me, but, you know, they'd never bunched up like this before. And I was trying to stay clear. Obviously, I didn't intentionally fall into the thing, but I just slipped. So here's kind of a summary of his injuries. I kind of mentioned them before. The main thing was the arm amputation. It was his left non-dominant arm, but still obviously a very serious injury and a permanent disfigurement. He had 4 surgeries after the accident. He had a rod inserted in his right arm, which was also significantly injured, and he didn't work for 10 months. So with respect to wage loss and earning capacity, the so-called special damages, he lost 11 months worth of wages. You could certainly see how this injury would prevent him, impair his future earnings capacity. That was kind of taken out of the case because Farmer Jones testified that Mr. Gonzalez would always be able to work for him. He'd find a job for him until his retirement age. So the future earnings capacity was not an issue. And I don't doubt that that was true. That Mr. Gonzalez had proved himself. He'd worked on that farm for 10 years and was a valued employee. And I'm sure Farmer Johnson was feeling a little bit guilty, but that seemed reasonable and credible that he was going to make sure he had a job going forward. Now, another area of special damages deals with what are his medical and health needs going forward. In the past, both incurred and going forward. Obviously, the cost of those surgeries and so forth was an incurred cost. But then you try to project going forward. What's he going to need for care and assistance? Can he cook? Can he shop? Can he take care of himself? In this case, Mr. Gonzalez was living at home with his kids, not with his wife for most of the time since the accident, but his kids were there. They lived as a community. They all shared in the shopping and the household duties, and he participated in that. And he certainly was capable of dressing himself, getting in and out of the house. You know, he was pretty independent. The plaintiff, on the other hand, said, "Oh, he's going to need 4 to 12 hours of assistance, and the family isn't good enough. We need trained medical people in there, at least for 4 hours to 12 hours, maybe as much as 12 hours a day, and $20 per hour." So they then project $1 million or $2 million or $3 million of lifetime costs for that. The defense position was that he may need some of that, some little help every so often with tasks, but $250,000 is a more reasonable sum for what he is really going to need. And note that damages are tailored to what this individual person is going to need. There's no book that you go look up and say, well, if he needs an in-home nurse, this is what it's going to cost. It depends on the community, it depends on the locale, it depends on the particular needs of this person. And then there's pain, suffering, and disfigurement. Obviously, these damages exist in this case. They're hard to value, and you wouldn't be surprised to know that the plaintiff and defendants have very different values as to what they thought a jury should award for those. So there's kind of a summary of what the plaintiff's damages claims were, and it comes up to between $6 and $8 million. Most of that is the pain, suffering, and disfigurement, although the $3 million for personal care and household is another way that the damage number gets inflated. You can see that the rest of the numbers are actually really quite modest, although the prosthesis is going to have to be replaced on a regular basis, so that's kind of an ongoing cost into the future. So the defendants, we certainly don't say he has no damages, but he does have a wage loss. He's got future prosthesis replacements and counseling and therapy. We don't contest that. And those amount to about $316,000. We don't agree that he needs $3 million in personal care. $262,000 would cover that, and $250,000 for the pain and suffering. So the defendant's position on damages is very substantially lower. Typically, that would be for a jury to decide which of those damages figures is correct and how should fault be allocated. Now let's talk a little about allocation of fault. These doctrines exist in all states, but to relative different tests, different formulations in each state. One is comparative negligence. Was the plaintiff at all at fault? And if so, the jury decides what percentage, and typically that percentage comes off the verdict. If he gets $1 million verdict, he's viewed to be 33% at fault, he gets $660,000. Third-party liability. Can a non-party like Farmer Johnson, can he be on the verdict form and can all the fault be allocated to him? Joint and several liability. Suppose Farmer Johnson has no insurance and he gets a big share of the fault, and Bush Hog, who does have insurance, gets a lesser share of the fault. Farmer Johnson, the plaintiff may not be able to collect against him because he's judgment proof. Is Bush Hog going to be on the hook for paying the difference? With respect to this case, workers' comp, in every state, the employer cannot be sued for damages in court because if the employee is covered by workers' comp. That's kind of the way the comp system works. It's a trade-off. The damages are less, but the employee gets the damages regardless of whether there was any fault on the part of anyone, himself or the employer or the manufacturer. So the farmer in this case would be protected by workers' comp. In the state where this case was decided, Mr. Gonzalez's fault was also irrelevant and could not be submitted to the jury because he was using equipment that had been provided by the employer. Now, Farmer Johnson could still be on the verdict form, but unless the jury found him 100% responsible, it wasn't going to inure to the benefit of the defendants who had funds, who had insurance funds available. And the way the law worked in this jurisdiction, if any defendant was assigned more than 60% of the fault, it could be responsible to pay 100% of the verdict amount, even if the other responsible defendant was judgment proof. So what are some of the lessons of this case? And if you look how it played out in practice, arguably the person most at fault for this accident was the farmer. He provided an unsafe machine. He knew it was unsafe, but he couldn't be reliable for any fault whatsoever because of workers' comp. The next in line, in my view, perhaps prejudice, was the plaintiff, who certainly was well aware of the fact that this was a very, very dangerous machine, and what he was doing was very negligent. But again, because of, in this case, because of the employer's workers' comp doctrine, his contributory fault could not even be presented to the jury. This is a somewhat unusual situation. In most states, his negligence in these circumstances would have been submissible to the jury. Bottom line, a jury wishing to give Gonzalez something has only Bush Hog and Massey Ferguson to choose between. And they can't do a reduction of fault for the farmer. Another lesson from the Gonzalez case, some damages categories can lend themselves to wildly different estimates, and the plaintiffs normally get an economist or a healthcare person that comes up with a boxcar number. The defendants come up with a different expert that comes up with a lesser number, and the jury, who generally is composed of people that don't have any experience with the home health care, with physical therapy, with any of the issues that are involved in treating a grievous injury over the future lifetime, they make a judgment, they make a decision. In this case, the impact of Mr. Gonzalez's ethnicity and his wage history was quite important. Injuring a guy who's earning $5 an hour is a better deal for the defendants than injuring a guy who's an investment banker. The potential for prejudice entered in, obviously, if you'd want to screen jurors to make sure that they didn't have any prejudice against Hispanics who were in the country without papers, that kind of thing. So all of these elements are things that all of the lawyers have to take into account in deciding what kind of jury they want and how much risk there is in not settling the case and taking it to trial. So that's Gonzalez. We'll now take a second look at a second case that I'm calling Smith, and here we're going to focus primarily on catastrophic injuries in a lawsuit. This was an 18-year-old man entangled in the driveline of a post hole digger, and he was essentially told to do what he did, which was quite silly and negligent by a farmer who had only $350,000 in insurance. Here's what the post hole digger looked like and the tractor it was attached to. You see a drive line there that has a little bit of shielding on it, but right at the business end of the post hole digger where he was supposed to be standing, that shield was missing, and obviously if that shaft was turning, there's a big entanglement hazard. This young man was essentially a functional paraplegic. He was paralyzed from the nipples down. He had lost his left arm at the shoulder. He was incontinent of bowel and bladder. Tragic injuries. Incurred damages were very substantial hospital bill and doctors and surgeons bills. He had a myoelectric arm that cost $127,000. He was probably going to need 6 or 7 of those projecting out through his lifetime. He had a lifetime of lost reduction of earnings, a lifetime of needing managed care. Who could argue with that? Rehabilitative equipment and so forth. Pain and suffering. Plaintiff had a vocational rehab expert that does a detailed assessment of what his needs are going to be. This surveys the employment opportunities in his geographic area. In this world of online employment, if he could be facile with a computer, that becomes a little more, his employment opportunities are broadened. What are the available wage levels for the work he's being capable of, and so forth. And then they come up with analyze his pre and post injury earning capacity. So with the annualized life care plan, here are the numbers that were developed by the rehab counselor, and it's about $200,000 a year for the rest of his life. It's a pretty substantial number. You project that out over 50 years, reduce it to present value, you're going to get a number in the multi-millions. I can't tell it off the top of my head, but 15, 20 million wouldn't be a bad guess. Obviously, if he goes to educational, possible future surgeries, more cost. Now, how does a plaintiff present that medical evidence with maximum impact? You don't just have some guy standing up there with a calculator saying, well, it's going to be this, it's going to be that. You get the ER personnel in there, you get the first responders. If there's been post-accident surgery, typically those surgeons, for whatever reason, that's usually photographed. If the police come to the scene, and there's usually photographs. So there have to be some fairly emotional and gory pictures that are going to be available to show the jury, and how many can, in what circumstances they can be shown is something the judge often has something to say with. You bring in the family members, you bring in friends who knew the person before and after, you bring in psychologists who've treated him. You present that evidence with the maximum impact if you are the plaintiff. And then here's some of the role of an economist who takes the numbers provided by the rehab counselor, the voc rehab person, and does calculations and reduces them to present value, including the earnings loss. Now, the defense, of course, has an economist as well. May want to quibble with some of the care as to whether it's reasonable and necessary. In this case, it was pretty hard to quibble with what was being prescribed. They made different assumptions about the inflation rate and so forth. The pain and suffering damages are not quantifiable in any, certainly not by an economist. And the plaintiff's lawyer, again, has the ability and the motive to present those damages with the maximum possible impact. It's very typical to have a day in the life video, and there was a heartbreaking one in this case showing that 15 minutes, what a typical day was for this young man and his mother, who was at this point in his life providing all of these services. She had to get him out of bed with a hoist and set him at the computer, all of his bowel and bladder care, just heartbreaking. In addition, friends, coaches, people that do it before and after, pre-accident and post-accident photos and videos, all of that is the way that these kind of damages get typically presented. Settlement strategies, if you don't want to take that case to a jury, there's arbitration as possible. The most common way cases are settled is through mediation. Once everybody kind of has taken some depositions and have the facts, they agree to meet before a mediator, who's usually an experienced judge, goes back and forth and helps them reach a middle ground settlement. Structured settlements are often common, and they may be useful in this era of low interest rates. They're not as useful as they used to be, but generally there's a tax advantage to that because a personal injury recovery is tax-free. If you get $5 million, that's tax-free. But if you take that $5 million and invest it, all the future earnings are taxable. In a structured settlement, you take that amount and you annuitize it so that the entire future income stream is tax-free. And often that is a better way to go for an injured plaintiff. If for example, if there's a young children in the injured plaintiff, you could put some 20-year out payments so to make sure that their college expenses are paid for. If there is insurance available, as I've said before, they may have paid some of these costs, but the jury's not going to know that, and it's not going to factor into their award. If public benefits have paid some of those, Medicare or Medicaid, historically in the workers' comp industry, there has been a requirement of a Medicare set-aside, whereas the governmental payments are some portion of the settlement is awarded, paid back to the government to reimburse them for the fees they have incurred to date. In the personal injury field, it's a little harder to do because those cases, a workers' comp case gets reduced to present value, and in 3 or 4 years, even if it's a lifetime injury, the case is resolved and a payment is made, a lump sum payment. Personal injury case, you're projecting boxcar type future injuries in some cases, and there's not such a clear demarcation as to when the case is over. Medicare, for the last several years, has been trying to apply Medicare set-asides into liability cases, but there isn't much guidance. There's been a pretty hostile reception to this on the part of courts and legislatures. And this is still in a very experimental stage. The law is evolving. But that's the future of this, is that Medicare is going to start in some form or fashion getting some recovery in settlements of liability cases. If there's a verdict in which the damages are allocated and there is a specific allocation, it makes it easier to determine what part of the payment is going for the medical expenses. Where there's a settlement, and one of the going questions is, do the parties have the right to say, well, we allocate all of this to pain and suffering, and we don't, we're not going to allocate any to the medical. At this point, I'm through with my presentation. I think you're going to be have the opportunity to ask some questions, and I'm going to sign off and turn that over to Paul again.
Well, thanks very much, George, for sharing your expertise in this area. We are going to be taking questions. We have several already that have been typed in. If you have any specific questions about how this applies to your work as an AgrAbility professional or somebody that's recommending assistive technology, please feel free to either type that into the chat window or raise your hand, and we will plan to activate your microphone so you can ask your question directly. While Kate Ham here on our staff is getting those questions ready for George, we would like to do our online poll questions to get your feedback on this particular webinar. So the first question that we always ask is what your affiliation is. If you could let us know if you are a professional in a particular area, if you're a consumer, family, or a farmer, even a gardener. You could let us know which category you fall into. Okay, mostly AgrAbility people. The second question asks, about the information that was shared today. Did you find this information to be valuable, and did it meet your expectations for this particular session? Give you just another couple seconds to respond on that one. Okay, thank you for your feedback on that. Next question asks about the technology that was used. Did you find the technology to be usable today? And if you did have any specific problems, for example, if you got kicked out of the room or had difficulty hearing, if you could fill us in specifically on those issues in the chat window, that would help us to try to pinpoint those and resolve them. Okay, it looks like most people did okay. That's always good to hear. And finally, based on today's session, would you attend another session in this series? And in fact, you will have one more opportunity to attend another session in this series. That is with Dick Brzezowski this afternoon. He's going to be talking about different strategies in choosing types of enterprises for people with limitations. So please plan to join us this afternoon at 3 o'clock Eastern Time for that session. And I will broadcast the results from this particular poll. So thank you very much for your input on that. This time I'm going to turn things back over to George, and he will be addressing your questions. Again, feel free to continue to type those in, or please raise your hand.
All right, I think I'm back. The first question I have is the protection afforded by workers' comp the same nationwide, or is it state by state statute? It's a function of the state, and each state has its own workers' comp program. One of the crucial differences among states is whether farm workers are protected at all under workers' comp. In many states they aren't, or there may be some requirement of only if you have only 2 or 3 employees, you're not required to participate in the workers' comp program. But it is definitely state by state. Next question. Any advice to AgrAbility staff members who are called to be witnesses in liability cases? Yes, go have a sit down with Bill Field, and when he is done, you will decide that you don't want to do it. Can you talk about liability where I would help a farmer custom adapt a set of steps on a tractor? It would not be a manufacturer case, but a goodwill helper. This is a question we have given some thought to on the advisory committee, and I can't really say that I have a lot of comfort to offer. It seems counterintuitive, but I believe that the fact that you were not paid for that, if you weren't paid, might in some states shield you from liability. It might not. Even if you are a volunteer, a good Samaritan, in most states you still have a duty. If you decide to be a good Samaritan, you have a duty to exercise reasonable care in being a good Samaritan. So you might not have a duty to be a goodwill helper, but once you undertake that, you have to perform that duty without negligence. And of course, if you're selling an adaptation, then you're right smack in the product liability area. You know, I hate to sound hard-hearted, but one thing you can say is that if your plaintiff is injured in that circumstance, you at least have the defense that, well, the plaintiff was previously injured, and so all I'm responsible for is whatever additional injury he suffered because of that. And I would, I guess, at least hope that plaintiffs in that situation would have some gratitude toward the people that had worked toward making their life better and might not be real anxious to sue them regardless of the offers that they received from plaintiffs' lawyers to do so. Next, do you have any general tips for minimizing liability for AgrAbility staff persons seeking to help a client? Suppose a client has a mobility problem that wants to get into a tractor. I think I pretty well covered that in the previous answer. I think the main thing is to just establish a good relationship with that person and do the best job you can to design that product safely and try to have some interaction with the client so that you appreciate how his or her particular limitations affect the functionality of that equipment. This really is sort of a tailor-made give-and-take situation, which is somewhat different from designing tractors off the line that have to be suitable for everyone. So in my mind, it would be very important to have a lot of feedback like that and perhaps document the feedback. If you think there's a safety feature that ought to be there, the client says, no, I really don't want that. There ought to be some record of that in your interaction with the person, and so that when they sign off and accept the machinery, you at least have made that record. How concerned should how concerned should AgrAbility staff members be about recommending technologies if they're not manufacturing or supplying them? What liability do they assume? That seems to me to be a bit of a reach if somebody wanted to try to make that claim. A general rule in the United States of America is that anybody can sue anybody for anything, so I certainly wouldn't want to tell you that there's no chance it could happen. It strikes me as being, you would not in that instance be the manufacturer of a product as is generally required for product liability in nearly every state. You're not providing the product or manufacturing or selling the product. You are not generally subject to product liability laws. That doesn't mean you couldn't be liable to negligence laws for giving supposedly bad advice. Is there any value at all for having a client sign a liability waiver? This is the last question. I wouldn't say there's no value to it, but generally those are deemed to be situations where there's an unequal bargaining power and they're not, generally they're not enforceable in circumstances where there's unequal bargaining power. So John Deere can't make you sign a liability waiver on your tractor and avoid future lawsuits because of that. And of course, the liability waiver, if you have one, is only as good as the person who signed the waiver, not his Aunt Tilly or his child or somebody else who was using the equipment. But if it's a custom-made thing and you generally feel that the client himself or herself is the one that's going to be using it, and you're not John Deere, I certainly wouldn't say it's a bad idea to get that, and it might very well stand up. But that would be an individual determination depending on what a particular judge in a particular jurisdiction thought about it. That being the last question, I think I'm going to sign off and turn it back to Paul. I thank you for participating today and wish you the best of luck in your work in this field, to which I know all of you are really, really dedicated, and I'm glad to have had at least some opportunity to be exposed to, both in my practice and with the advisory committee. Thank you.
And George, thank you again for your expertise and for all the time you've committed to not only presenting today, but also preparing for this presentation. Again, we have one more session this afternoon, so we hope that you will participate in that. We will be archiving this on our website as it's listed on your screen there, so you have an opportunity to check back later if you would like to review any of the points that were made. So thank you and have a good rest of the day.